Welcome to another episode of Scroll's podcast slash YouTube show called Scroll Ideas. If you're new here, what is Scroll Ideas? Well, every episode we'll take one idea, one topic, one issue that Indians are debating, discussing, and maybe even fighting over, and we will discuss that and break it down for you over the course of an hour with a particularly brainy guest. This week we have actually two very brainy guests. We've got Aparna Chandra and William Hubbard, who, along with their co-author Seetal Kalantri, have written this fantastic book called Court on Trial. I'm getting it on screen. Uh, we've had a lot of discussion of the Indian judiciary of the past decade, which is both good and bad. I mean, good. It's always good to discuss and debate stuff, but a lot of it is coming from a conception or an idea that the court is in crisis, which is something that the book also says. What I liked about this book is that it uses data to make its points. It puts forward a series of policy prescriptions, and of course, putting forward policy prescriptions is quite common. I've done it myself a couple of times. But what this book does is it uses a large number of data sets and the puts forward the problems as well as the arguments that it thinks will solve these issues. To quote from the book itself, which says, "For far too long, conversation on the court and its reform have been based on impressionist anecdotal tales, often derived from a few high-profile cases rather than on overall trends and patterns based on rigorous studies." This is something that I've noticed as well. In fact, I've written about this a couple of years back. For some reason, when we think about government policy on the executive side as well as the legislative side, the idea of using data is almost natural. Nobody's going to talk about solving, say, malnutrition without using data. But somehow, at least in India, the idea of using data when solving policy problems on the judicial side is rare. People usually make very strong arguments using anecdotal data, which is, I'm not sure why it's done, but it is what it is. But this book aims to solve a bit of that. Hi, Aparna and William. How's it going?
Hi,
Good,
sure.
thank you.
Thanks for having us here.
Very glad to have you and look forward to what will be an hour long, very meaty discussion. Before I begin, I just want to put out a small request to our viewers. If you like what you see, if you like the work that Scroll does, I urge you to go to scroll.in/contribute and put in whatever donation, whatever membership that you feel like so that we can continue to do the work we do. Back to you guys. The number one, I think, speaking as a regular Indian, a regular person, the number one problem at the courts seems to be the immense backlog that we have. Just talking of I've grown up, I think it's a common thing amongst people in India. Going to the courts is almost like a last resort just because it's so difficult to get a verdict out on time. People would almost uh, look through various extra legal means, including some very dodgy means, rather than go to a court because it seemed to be so time consuming, so expensive, so troublesome. In fact, in Hindi, when you say court kacheri ka mamla, it's almost like it's a terrible thing. It's like the worst thing that can befall a family. You guys have really dug deep into why the courts, as well as the Supreme Court specifically, has such a backlog, and you sort of dismiss the notion that this is a lower court problem. You say that it is a very much an all judicial problem. Why don't you break it down? Why do we think we have such a big backlog? Is it normal for judiciaries around the world to have this sort of backlog, or is this a very Indian issue?
Well, I'll jump
Thank.
in.
Go
I'll
ahead.
jump in with one comment, and then I'll turn it over to Aparna, who has a lot of expertise to share on this topic. I'll just note, as an American lawyer myself, I'll speak for the for the United States. The issue of backlog is one that courts all over the world have to face, and all over the world address in various ways, have attempted to address in various ways over time. It's been a persistent topic of conversation among judges in the United States for decades. Now, having said that, there is a lot of variance from country to country in terms of how long these backlogs actually are. And one of the things that jumps out when one looks at the Indian judiciary is the fact that the backlogs are long, even compared to other countries like the United States, where we complain about backlogs as well. So the typical length of a court case in United States federal court will be under 2 years, and that's true both for the trial level courts, the courts where cases are first filed, as well as the United States Supreme Court. It's also going to be less than 2 years. In comparison, when you look at the Indian court system, the backlogs are much longer. And as you pointed out, that's true both at the lower court level and at the level of the Supreme Court itself.
Right.
And just to add a few things to that, in India we tend to talk about pendency, right? And you'll hear that there's a lot of pendency in courts. Now, pendency is different from backlogs. Pendency is a good thing. Pendency means that there are cases that have gone into the system that haven't come out. And it's good for the court to have a lot of business. That means that people are relying on courts to get their job done and not relying on dodgy means, as you were talking about. Backlog is talking about cases that have been pending in the system for a long time. And we can have a difference of opinion of what is too long and what is not. But and in the book, we provide some facts and figures of how long cases are taking in the system. But one of the reasons why, at least at the level of the Supreme Court, there is such a backlog is because, as we find, it's a self-inflicted problem, right? The Supreme Court uh, was supposed to be primarily a constitutional court, which means that it was supposed to be primarily a court which would decide on constitutional issues. It would enforce constitutional norms, hold the state accountable for constitutional violations. That was seen as being the soul of the Constitution, soul of the work of the Supreme Court. Additionally, just because it was also in some ways replacing the Privy Council as the highest court because of independence, um, it had some limited appellate powers. And the entire discussion there really was to say that matters will lie with the high courts. When high courts exceptionally felt that there was some very important matter that required the Supreme Court to consider it, then they'd send it to the Supreme Court would consider it. And exceptionally, just as the Privy Council had the power to take cases on its own or at its own discretion, therefore, as an exceptional residual category, why should our court be any different from or any lesser than Privy Council? So let's give this court also that power to exceptionally in exceptional residual categories when there's some very grave injustice that's happened or there's some very serious question, but the high courts haven't sent it up. Maybe the Supreme Court can take it up. And that is the special leave to appeal, which at the discretion of the court could admit. But it was very much understood to be an exceptional power. What has happened over time is that the Supreme Court has expanded this power and used it very expansively, rather, without putting down any criteria or any sort of cogent criteria on when it should take cases. And today, the bulk, the overwhelming bulk, about 90 odd percent of all the cases that the court has on its docket are all SLPs. They're not even those appeals where the high courts have certified that yes, this is an important matter, the Supreme Court should discuss it. That's hardly a small percentage of what the court is doing. So the court has become today, from being primarily a constitutional court to primarily an appeals court, an ordinary appeals court. Just like you have from the trial court, you appeal to the high court. From the high court, as a matter of course, you appeal to the Supreme Court. And what that ends up doing is, where is it putting, and someone has to resolve all these cases are clogging the system. So where do you feel the pressure? You feel the pressure in resolving these constitutional cases, which often require larger benches to be set up. So instead of setting those up, because they'll take time and they'll take more judicial resources, more judges will have to sit on those benches. It's easier to, deal with these minor appeal matters, which is where the court spends the bulk of its time. So this the backlog, apart from the fact that it takes a lot of time for the court to resolve these disputes. So we found an average for a case that travels all the way up. On average, it takes about 13 years to travel up to the system. That's only on average. I mean, the outliers will be many, many more years than that. Um, but it's not just about the individual and that individual case taking that much time. It has a systemic consequence for the ability of the court to enforce its constitutional responsibilities and to carry out its constitutional functions, because it just doesn't have the time to do that.
And so the world that you describe, Aparna, is something I think a Indian in 2023 would find very difficult to even envisage. That the High Court is the highest court of appeal, and Supreme Court is barely in the picture unless unless you're a law nerd, basically. Uh, when does this start changing? When does the Supreme Court become this incredible vacuum pump for cases from the high courts? What's the inflection point? Because that's not how it was designed. That's not how I think whatever the earlier Government of India Act or the Constitution envisaged the federal court to be. What's the inflection point?
If I may, there's concerns already being raised that the number of cases that we're taking up is too much for us to handle. In fact, you see, the original Supreme Court, as envisaged in the Constitution in 1950, was supposed to have 8 judges, and then in the 1960s, they're already increasing the number of judges because they're getting much more volume of cases. But the inflection point, it happens at a very interesting moment in the court's history, which is right after the emergency, where the court has faced a lot of criticism in the decade past,
Right.
both from the Indira Gandhi government. These are the battles that are happening with the executive. That will be familiar to those of us who are familiar with Indian constitutional history or Indian politics, where Indira Gandhi's government has gone hammer and tongs against the judiciary, and particularly for holding back many of her reform proposals. During the emergency, the 42nd Amendment takes away a lot of the powers or tries to take away a lot of powers of the judiciary, and the judiciary also completely abdicates its responsibility during the emergency with the infamous ADM Jabalpur case. So right after the emergency, in what is seen as a way to re-establish its reputation, the court and judges of the court very consciously reimagine the role of the court, and they start speaking of themselves as the people's court, and they start using the language of, so this is the birth of the public interest litigation that we are very familiar with, the idea that the court should be very easily accessible, etc., etc., right? And alongside, at the same time, they're saying, so they're broadening access to the court. One way in which they're
Right.
broadening access to the court is by saying that we'll take in all of these cases. Every time we get a case from someone who we feel is disadvantaged, we want to give it another look and make sure that justice has been done. And one can understand the impulse and appreciate that impulse
Mm.
of broadening access. But unfortunately, what ends up happening is that the court does not look at the institutional consequences of such a broad access right to the Supreme Court, right? Which is that it limits its own ability, the court's ability, to perform the core functions that it has to perform, which is of both enforcing constitutional norms, but also ensuring that it lays down clear standards that other courts can follow. Because unfortunately, what it ends up doing, this is something that we describe in our book, is that it confuses access to the Supreme Court with the broader idea of access to justice, which clearly it is not the case. Access to justice for most people means access to the trial courts. The Chief Justice of India was here for our convocation over the weekend, And he said something which I think is absolutely true to what we find as well, which is that he said that the court of first instance, which is the trial court, is most often the court of last resort for the majority of Indians, right? People go to the trial court and they don't go up. So access to justice actually means access to should mean access to the trial courts and good results from trial courts, which the Supreme Court can aid by having good clear rules that it announces, rather than taking all on these cases to itself to ensure that it takes a look at the at the case again and sees whether justice was done in those cases or not. Because of the millions of cases that are coming out of the trial courts and the high court, there's only a small percentage that actually reaches the Supreme Court. So
Yep.
instead of performing what someone described to us as case by case rescue, it makes more sense for it to do more systemic reform and more systemic take on more systemic matters that can ensure that at the lower levels there is better quality of justice.
Right. So this is a bit of a counterintuitive idea, I think, for most of us, especially in how I think the mass media reports on the judiciary. You're actually saying that by taking in a lot of cases, the court isn't actually doing a very good thing. It might do better by taking in fewer cases and setting clearer standards. And one of the examples that as part of a newsroom, I have to constantly go through judgments. Sometimes I see judgments not even refer to other judgments or even set down clear norms. They only solve for that issue, and that's great for the ladies and gentlemen involved in that case, maybe. But if it doesn't set a precedent, that could basically clear the way for thousands of, I don't know, tens of thousands of cases down the line. So is that what you would like the court to do? Take in fewer cases and set norms?
Yes, that's what we have in mind. And to just add to what Aparna has been saying, when you have literally millions of cases that are pending in the trial courts and the high courts of India, and the Supreme Court itself is only able to issue something like 1,000 judgments per year, what that means is for every individual person that the Supreme Court has been able to review their case and do justice in their case as the Supreme Court sees it, there are, for each of those people, 1,000, literally 1,000 other people in the system facing trial, facing appeal throughout all of the Indian courts, who will never step inside the Supreme Court of India. And those courts, those judges who will decide the fate of their cases, do not have guidance from the Supreme Court of India in these judgments that are issued that refer to no precedent, and importantly, set no precedent as well. The Supreme Court rarely ever cites any case the Supreme Court issues is rarely ever cited again by the Supreme Court itself. And so that's what's lacking. If you look at what constitutional courts throughout the world focus on, and the Indian Supreme Court is, of course, in addition to being the highest court of appeal in India, is the constitutional court for the country. Constitutional courts in other countries focus on a much smaller number of cases. Very often, I'm by no means advocating that the United States is a model. I actually think the United States Supreme Court decides too few cases. They decide something like 60, 70 cases a year,
Right.
when we might think they should be doing a little more lawmaking than that. But the advantage of being so selective in hearing cases and deciding cases is each case is carefully connected to the cases that came before it, and each case lays down guidelines, rules sometimes, that subsequent cases can then follow, allowing whatever issue was raised in that case to be decided once and for all. It might be changed in the future, it might be overruled in the future. We've certainly seen plenty of that in the U.S. But to have a rule laid down so that for years to come, lower courts can then say, in this case, the Supreme Court said the rule was X. We will do X. And there's no need for uncertainty. There's no need for disagreement among courts. There's no need for inconsistency across cases. And that's the vision that we have for the Supreme Court of India, elevating to its original intended status its role as the constitutional court for the country, rather than prioritizing its role as simply another court of appeal, when the high courts are already fulfilling that role as a court of appeal to correct errors that might be made by the trial courts.
Right.
I'll
I
just
mean,
add one more
yeah.
point, just to say, Shoaib,
Go on.
that
Yeah.
one of the concerns, and I know it sounds counterintuitive, also one, because we are used to, the system where we see approaching the Supreme Court as so integrally sort of associated with the idea of getting justice out of the system, right? But also, uh, the court itself has very little faith in the lower courts. So that's why when you see any discussion that's happened in the past about limiting the Supreme Court's SLP jurisdiction, the counter always is, but the lower courts are in disarray. And if we don't have this wide power of, essentially policing what it is that the lower courts are doing, then these courts are going to go off and do all sorts of problematic things. But actually, if you look at the data, that doesn't bear out this idea of systemic malfunction, right? At least in the sense of the outcomes in cases. So, for example, there are about 60,000 odd petitions that are of petitions that come up for admission before the court, appeals or petitions or things like that. Appeals in particular, about 60,000. Out of those, the Supreme Court, on its face, rejects about between 92 to 94%. Right. So at that first hearing on a Monday morning,
Right.
where a lawyer gets up and says, please admit my matter, the Supreme Court says no, and that's the bulk. That's 92 to 94%. Out of the remaining, 6-7% of cases where the Supreme Court agrees to take another look, right, deeper look in the matter, roughly half of them, it finds that the lower courts have done a fair job, right? So ultimately, it is about between 3 to 4% of cases that are coming to the Supreme Court, where the Supreme Court says that no, actually, we found a problem here, right?
Right.
So it's not as if the cases that are coming before the courts are showing that there's some kind of systemic malfunction in the system. So that's
And
just something to keep in mind, to think about, and there might be, maybe there are other cases where there's a lot of injustice happening, but they're not reaching the Supreme Court, right? And possibly because people who are facing that systemic injustice can't afford to wait so long in the Supreme Court to get the case
I think
heard,
that's
and so they don't
even
come.
if we
Yeah.
even if we assume that the low courts in India are terrible, I think just
Hmm.
the numbers that make it up to the Supreme Court are so small that we have no other
Small.
option but to reform the system. I mean, the Supreme Court could be,
Yeah.
jumping through hoops for all we care, but I mean, it's not going to
Yeah.
be able to fix,
Yeah.
the judiciary for 1.3 billion people. Exactly. I mean, even for some, I don't know, like, I'm a journalist, I move, and I know a lot of lawyers. Even for me, going to the Supreme Court would be shocking, to have a case that goes all to the Supreme Court. I would be stressed out. I would be really stressed out. So I can imagine that you wouldn't want to be in that situation. I want to dig slightly deeper into this because this is so integral, again, like I said, to how a common Indian associates and interacts with the judicial system. Later on in your book, you guys talk about uh, a system of incredibly powerful lawyers that are there in the Supreme Court. I think a paper around a decade back had called them the Grand Advocates of India, and so on and so forth. Uh, so, what I want to dig, so one thing that you raised, Aparna, is there was a post emergency calibration of the court. The court moved to a more populist, so-called populist POV. Is there also a political economy? Because if I'm looking at this system that you criticize, but I'm a grand advocate, this system works great for me, right? If what you said, if what the three of you all said actually came true, and the Supreme Court became a purely constitutional court, I'd be out of a job. right? So, is does the political order of the Supreme Court, the way it exists now, does it map onto the existence of uh, an ecosystem of grand advocates? Is that a factor in how the Supreme Court moves?
Yes, I think that's a very sensible inference from what we see, that the actors in the current system are happy with the status quo, and they're maintaining it. I do want to sound a somewhat more optimistic note, though, in the following sense. It is true that one of the great sources of income for senior advocates and grant advocates in particular is being able to charge a hefty fee for a very, very brief court appearance. And because the Supreme Court has so many SLPs that it's hearing every Monday and Friday, these hearings last, on average, one study found, less than 2 minutes each. So these are very brief hearings, but grand advocates can make an appearance, speak for 2 minutes, and if they can make an impression upon the court, and that's what they get paid
Right.
so much to do, they can give their clients a leg up, more access to the court than somebody who can't afford a grand advocate. And so I think, you know, just as an aside, I'll note that when we talk about access to the Supreme Court is not the same thing as access to justice. When the best way to get access to the Supreme Court is to pay a grand advocate a princely sum to speak for 2 minutes, that's access that very, very few people can afford. So that is part of the business model for senior advocates and grant advocates. That is a great source of income for them, and it is part of the current system where there are tens of thousands of SLPs being heard every year by the court in these very brief hearings. Having said that, I think it is worth noting that if one looks at other constitutional courts, there are very prestigious bar associations in other countries where their Supreme Courts have smaller dockets. The United States Supreme Court, as I said, I think has the opposite problem. Its docket may be too small, but there are very well paid and very prestigious lawyers and law firms who have a Supreme Court practice in the United States. So it's not impossible for the elite of a Supreme Court bar to do very well, even when the Supreme Court is being highly selective and is very
Right.
focused on its role as a constitutional court. So I'll just note that India is the largest democracy in the world. It has the largest court system of any democracy in the world. It dwarfs the United States court system in terms of the scale of cases and justice that it dispenses. And what that tells me is even a Supreme Court of India that is much more focused on creating precedent, on creating norms that lower courts can follow, being more selective in the cases that it hears, is still going to have a lot of work. And in that lot of work that it's going to be doing, senior advocates and grand advocates are still going to have a lot to contribute to the work of the court. So, in my optimistic view, I think that a shift towards a court that's more focused on its constitutional role uh, will be a shift that senior advocates and grand advocates will be able to take advantage of and continue to thrive and continue to succeed in their very important and prestigious roles in the Indian bar.
I'll just add a couple of very minor points. One is to say that, I was remembering this is not something we discuss in the book, but when the Supreme Court was set up, the high courts were the more prestigious institutions, right?
Which is
These
why
had
you
been
have the
around for.
retirement age gap, right?
Yeah.
Right.
The
Yeah.
retirement, because they didn't want to come up to the
Yeah.
Supreme Court. So that it was the opposite
Mhm.
problem, that people wanted to be
Right.
they prestige was associated with high courts. They didn't want to come up to this new kid on the block, the Supreme Court,
Yeah.
where we won't even have power. In fact, even under the current constitution, administratively, the Supreme Court doesn't have any control over the high courts. The high courts have control over the lower courts. A chief justice of a high court has may have more power than a judge, a puny judge of the Supreme Court. But the biggest lawyers of the day were then therefore high court lawyers, and they'd come up occasionally to the Supreme Court, right? So it's not as if the Supreme Court were to stop taking cases, that lawyers would be out of work. It's just that their work might shift to other places, right? And just to give you
Right.
an example, when tribunals got set up across the country in the 80s and subsequently, many lawyers who used to focus on their practice in the courts moved to tribunal practice as a lucrative sort of venue. So that's a venue shifting issue. Second is,
Right.
we are not saying do away with the SLP jurisdiction or the appellate jurisdictions. As William noted, there will still be a lot of work there, and the volume of cases is such that the volume will still be high. It might not be as high as it is currently. um, One of the other point that I just wanted to mention was that in order to get around this sort of political economy question, some of the measures that are being suggested and that are being explored, both on the judicial side and on the administrative side, might be actually might end up creating a bunch of problems for the Supreme Court. So one such proposal is that of setting up a national court of appeals. The idea is that you have a national court of appeals, which will be the final court of appeals, and then there'll be a Supreme Court on top, which will have the this constitutional jurisdiction. The problem, unfortunately, with that is that you're just again shifting the site of the problem now to a national court of appeals, because if it's just taking on all of these cases, the same problems will arise there. The second thing is, then is there going to be an appeal from the national court of appeals to the Supreme Court? You can't completely exclude that, because there might be constitutional matters that arise that go up to the national court of appeals. We've seen in other countries where if you have a separate appellate system and a separate constitutional court system, that clashes between the two are very common. So you'd have to have some conflict resolution mechanism. And if there you were to continue with this model where you could technically appeal to the Supreme Court, then our sense of justice would be that, why should my case stop at the National Court of Appeals? It should go all the way to the Supreme Court, and we'd just be replicating the problem in either in a different place or just doubling up the problem.
Got it. I want to move to what is the other, I think, big issue with the court, and especially that's come up recently, is the idea of master of the roster. That there was an infamous press conference a few years back where actually courts judges came out in a very unusual, in very unusual circumstances, and addressed the media. I was actually there when they were addressing it. It was very interesting, and that was the first time that I think the average Indian maybe even came to know that there was something called a master of the roster, and the immense power that this had. The most recent, I think, most recent couple of instances of this is when there were demolitions in New in Haryana. There was a bench that was quite critical of the demolitions, even calling it an act of ethnic cleansing. That bench was immediately changed. Uh, just even more recently, there has been a verdict which was reserved actually in the Allahabad High Court. But even more unusually, even after the verdict got reserved, the case actually got transferred to a bench of the CJI. So we know this. We know that this problem, this issue
Sorry,
exists.
the Chief Justice of Allahabad, not the CJI.
Oh, sorry, the Chief Justice of Allahabad. You're right, not the
Yeah, yeah.
CJI. So the Chief Justice of the High Court. So we know this problem anecdotally, but you guys have worked this out using much larger sets of data. Tell us why you really think that the courts have a master of the roster issue, and maybe what are some of the solutions that you guys have thought of.
Maybe let me go first on this. When you have multi-panel courts, right? Courts where judges sit in different benches and panels, there will always be a question about how do you allocate cases to these benches and who gets to sit with whom, right? And different countries have struggled with this. Some have automated this, some have done other things. What happened with the Indian Supreme Court was this: when it was formed in 1950, it had about 8 judges. While there was no rule that all of them had to sit together, very often they did. or they sat in very large benches, and they had very few matters, right? So, I mean, very few compared to today. They had quite a bit of matters, but compared to today, they had few matters. So, the Chief Justice, who had the power to allocate, to decide who will hear what case, didn't have much of a power, because, you either sent it to one 5 judge or 6 judge bench, or you sent it to one 2 or 3 judge bench, and you would send all the important matters to the 5 judge bench, and you didn't send all the appeals and, the ordinary matters to the 3 judge bench. Um, and there was literally nothing else that was envisaged here. So this was seen as an ordinary administrative role that the Chief Justice, someone has to do it, the Chief Justice might as well do it. What has happened is, as the court has grown in size, you now have many more benches, right? So much more choice for the Chief Justice, plus many more cases. So the Chief Justice has much, much more discretion in who is to hear what matter. Now, as a regular matter, what happens, the way this works out is that the Chief Justice will draw a subject matter roster, right? So they might say all labor matters will go before these 2 judges, will be on a labor bench, and all the labor matters will go before them. All the environment matters will go before someone else, so on and so forth. Right? So this is all set, and the registry will just look at, whatever this fits in. Registry has certain subject matter categorizations. It will see what subject matter this falls in, and automatically assign the case to the bench. As a general matter, this is how this works. So if you go onto the Supreme Court website, you can see the judges roster now. This actually happened. The judges roster was made public after the press conference. But in the most important cases where there is conflicting precedent, or where there's a very important question, a larger bench has to be created, right? So a 3 judge or a 5, 7, 9 judge bench. These cannot be preset. So now the Chief Justice has to set a 5 judge bench, for example, to hear any matter which has a substantial question as to the interpretation of the Constitution. For example, the current 370 matter that's going on. Now, what has happened is the Chief Justice has two powers here, right? The Chief Justice first can decide who will be on that bench, right?
Right.
The second thing that the Chief Justice can decide is when the bench will be constituted. So, as in the 370 matter, right, 2019 is when the abrogation takes place. We are in 2023. 4 years down the line is when the Supreme Court is hearing this matter. I mean, there's a whole pandemic that's happened in between these two
In a
moments,
way,
and
the court has
everything else that
already
we
heard
know
the matter by not hearing the matter.
by
Right.
not
I
hearing
mean,
the matter, right? So it's
it's
decided the matter
ignored.
by
Yeah.
not deciding the matter. It
Yeah.
allows the court, it allows the Chief Justice, no one else, not the court. It allows the
Right.
Chief Justice to evade deciding a matter by not setting up a bench, right? But
Hmm.
the other thing is, the Chief Justice can also decide who will be on this bench. Now, why that is important is because there is so much subjectivity in the law, right? Different judges look at the same rule in very different ways. That's why you have
Hmm.
dissents. That's why you have disagreements. That's why you have two sides to a case, right? And so, who the judge is very important in terms of what the outcome of that case might be. Now, what we found, and we are not alone in finding this. This is a finding that we are seeing in different studies from the 1950s onwards,
Right.
is that in the period that we are studying, which is the 2010 onwards, the Chief Justice of India has a tendency to over assign these benches to himself, right? So he will always be on the bench, and I'm saying he because it's always been a he. He will always be on the bench. No other judge gets to be on the bench so often, right? The second senior most judge is 4 times less likely to be on the bench than the Chief Justice. So seniority is not a consideration. Um,
Sorry, what
the
bench is this, Aparna, for our
the
viewers?
constitution bench, like a five
Right.
judge bench,
Right.
or a larger bench that has to be created, five
Right.
judge bench or more, right?
If
So
it's a
in
really
these benches,
important constitution case, we find the CGI
case
to be, self-selecting
CJI
himself a
will
bit more.
self-selecting himself. But the interesting thing is, and not, it's not as if it's based on seniority, because the next senior most judge is is, like I said, 4 times less likely to be on the bench than the Chief Justice.
Right.
So they're not following a seniority norm, but the Chief Justice puts themselves on the bench. But the other interesting thing is that the Chief Justice is almost never in a minority in these cases. So the Chief Justice who's constituted the bench is almost always in the majority in these matters. Again, no other judge can claim that level of, carrying the majority with them. So there are dissents. These are important cases. There are different
Right.
views. There will be dissents on these cases. But the Chief Justice has this unique ability for some reason, and we can imagine what that reason is, some reason to always carry the bench with them, right? Always carry them, always be in the majority. So in the all the cases that we studied from 2010 to 2019, that's a time period, the Chief Justice was in a minority in one case. And this was a
Wow.
judgment. This was the Shara Banu case on the triple talaq case, where the Chief Justice was delivered that judgment on his last day in office. In no other constitution bench has the Chief Justice been in a minority. This is again a feat no one can equal. Which means, what does that indicate? That indicates that the Chief Justice, in constituting the bench, the Chief Justice somehow always ends up constituting a bench which agrees in the majority with his view. And
He's
that's a
really
very
lucky.
dangerous power to have. There's a very dangerous power to have,
Right.
um, for any one person, right? To say that, I'm always in the right. uh, the systemic danger is this, right? It's not a
Right.
question about one or the other Chief Justice. The systemic danger is this, that it if judicial independence depends on our having a faith that the in the system as a whole, and knowing that the cases are being decided according to the merits of the case, and not for extremist reasons. You're creating a very fragile system where, if one point falls, the independence of the entire system falls, right? And that's the concern. That was precisely the concern that the judges of the Supreme Court had, the four judges of the court had during that press conference. Unfortunately, as we know, and I mean, I'm sure you or your team would have reported on this as well. One of those judges, who did the press conference was Justice Ranjan Gogoi, and when he became the Chief Justice, as the next in line, when he became the Chief Justice, he obviously used the Master of the Roster powers, even more problematic ways.
Yeah, I think there's a good argument to be made. I don't know whether it's a problem of observation. Sometimes things seem to be becoming worse when we observe them a bit more, but it might have even become worse since the press conference, uh, ironically enough. What is the solution? So, I mean, one of the interesting things is, we done a story around a legal cost, story around, I think, a couple of years back, when Nepal had the same problem, and they just use a lottery to pull out cases. I'm not sure where it is right now, but that was one of the main proposals when we had done the story. I had to go back and check. What do you guys propose? Because this is, it's a really incredibly complex issue, and B, uh, it's a really difficult policy problem to solve, because the only person who can solve it is the Chief Justice, but he's also the guy who's the guy who's with the most power. So how do you untie this knot?
William, would you want to?
Oh, I'll just make one very small comment, but Aparna is the constitutional law expert between the two of us, so I don't think I should be saying too much on these very, I think, subtle and, as you say, difficult questions of reform in a constitutional court. I think the political economy question, as you note, is a very difficult one. One of the things that may make it more possible for there to be reform is, ironically, one of the things that we think is not a benefit of the current design of the Indian Supreme Court, which is the relatively short tenure of the Chief Justices of India. And one of the ways to think about making reform more feasible is having it apply prospectively, and saying we will phase in the reforms over a period of time. That means that whoever the current Chief Justice of India is doesn't necessarily have a reason to object to the system changing if it's
Right.
going to change after he has to retire anyway. So that's just a comment about the political economy side of it that I wanted to offer.
So, after the press conference, two cases go up before the Supreme Court, which are both asking for reforms in this master of the roster power. Shanti Bhushan files one case, and there's another person called Ashok Pandey who files the other one. And in both those cases, the Supreme Court says, the Chief Justice of India is a high constitutional functionary, so you should trust this the Chief Justice of India. Now, what we say in our book is obviously this idea that you should just trust constitutional functionaries is antithetical to a democracy, right? We don't trust, we hold you accountable. That is the way in which democracies function. And so, therefore, what is the accountability mechanism that one can build in? What we are suggesting is that where automation is possible and where the Supreme Court's already anyway automated it for subject matter general allocations as a regular matter, that is fine. But when it comes to these larger benches, which either you create a permanent bench or a permanent division of the court, which is a constitutional division or a constitutional bench, which is always going to be sitting. There's always work for at least a 5 judge bench. If there isn't, then you can shift them to the appellate side. But to the extent that
Right.
there is, they decide these constitutional matters, and there are enough pending right now. But on the other hand, there will still be issues where some judge has to recuse themselves, or some other for some other reasons. Whoever you've put on some kind of a bench, however you've constituted it for one go, cannot be on that bench. And what we are suggesting is have some clear norms, right? Whatever those norms are. Seniority might be a norm. It's an objective norm. It doesn't matter then. It's not so much a question of who the judge is, but what their position in the hierarchy is. Maybe keep seniority as a norm. If you need to depart from seniority, then you have to give reasons in writing for why you're doing that, right? This is not a power that you make at your own whim. This is something that you're accountable for. Now, this is something that the Supreme Court, these kind of strategies, is something that the Supreme Court enforces on a daily basis in your regular administrative law matters, right? Where
Hmm.
you say that you have your default rules, and if you have to depart, if you have discretion, then you have to record reasons for why you're exercising discretion going against the default rules. Standard, any administrative matter you go before the court, these are standard things that the court does. This is an administrative power. Return it to that field of administrative power. Use the tools that you have in administrative law of accountability of state power, and use that, so that the Chief Justice, it cannot just be that we are trusting the Chief Justice to do the right thing. We need to know that the Chief Justice is doing the right thing, and therefore give us the rule, give us your broad principles, and give us why you're deviating from those broad principles, so that at least there's some transparency in the system.
Okay. I'm going to go off your point, Aparna, of going on trust on judicial officers and go on to another issue that I think this engenders, and which might even be a bigger issue than master roster, is the Collegium. So the Collegium was set up. India has a very unique system, as you guys point out in the book, where judges select judges, which is an interesting system. But from my point of view, really, what is most problematic about the system, that is a completely secretive system. We don't know why judges are selected. We don't know why these people are being picked. Again, I think we're supposed to trust judges because they have the best faith involved. But as you said, that's not how a democracy is supposed to work. It's all based on a system of checks and balances. What I want you to guys to unpack is uh, so one of the very interesting things that I find, for example, William, in the US is Supreme Court judges are grilled by an arm of the legislature. And while it might get a bit dirty and problematic at times, but I find the level of public involvement in this process quite remarkable. And India is obviously the literal polar opposite. Do you think that having such a secretive process impacts the power that the Indian judiciary has, because it distracts or subtracts from its stated role as a people's court?
Well, I think it is in tension with its stated role as a people's court, being that it is, um, because it's insulated from the democratic process, it has less of a claim to legitimacy by having its roots, by having the selection of judges be rooted in a process that involves democratic actors. Now, to be clear, I certainly don't want to fully endorse the American approach to the nomination and confirmation of judges and Supreme Court justices. Um, in particular. But one thing that is very true about the American process is the very high degree of public involvement, both in terms of interest groups and politicians, uh, lobbying and negotiating, discussing who they want the judges to be based on their political beliefs, based on what they think the constituents might want, but also the public as a whole being aware of the process that this person has been nominated, this person is under scrutiny, and so on. I think that does a lot for ensuring that the process of selecting judges is one that is part of a democratic system in which elected officials and the public as a whole are connected to it. Now, having said that, there's plenty of dysfunction in the American system. There's plenty to criticize in the American system. And so I don't want to oversell those values, but I think those are values. Those are important values in a um, in a democratic system. I'll add that when you look at the Collegium, it's not it's undemocratic in another sense as well, and not merely that the process of selection doesn't involve political actors or the public, but if you look at who is becoming a judge of the Supreme Court of India, since the Collegium became the process for selecting judges in 1993, what we find in the book is that the variety of backgrounds of individuals who become Supreme Court justices has actually declined, declined from the pre-collegium period to the period now where there's basically one pathway to becoming a judge on the Supreme Court of India. Of course, there are exceptions. I don't want to claim otherwise, but overwhelmingly, the judges of the Supreme Court of India follow a single path to the Supreme Court, which is uh, they are high court judges. They are the chief judges of their high courts, and then they are elevated from chief judge of a high court to the Supreme Court of India. And what that means is the ability for different backgrounds, different experiences in terms of professional life and political life to be represented on the Supreme Court of India is limited because the pathways to reach the Supreme Court of India are fewer than they were in the past. And that's one of the things that we point out in the book, observing that the Collegium has not, for most of the time period since 1993, it did not make much progress, if any, in terms of the uh, the gender or caste diversity in the Supreme Court. Regional and religious diversity were always well represented in the Supreme Court, both before and after the Collegium. But what went down was the diversity in professional backgrounds.
Right. In fact, this is one of the most powerful attacks in the popular domain against the court, that it is not diverse, and it's a very intuitive thing that obviously everyone catches on to. From the sense that I got from your book is that you guys do favor something like an appointments commission, although an appointments commission was struck down by the Supreme Court in 2015. Uh, is that what it is? And what would an appointment commission, what would an ideal appointments commission for you guys look like?
I can take that question. We actually don't say much on whether it should
Right.
be an appointments commission or not. But one thing we can say that there were, I mean, I can say, I don't want to attribute this to William or Seetal, but this is the meat of the work that I do. So I can say that I find the NJC system very problematic. And I think The court was broadly right in the conclusion that it reached. I may have some problems with its approach. But a few of the things that the commission got right is this kind of broad basing of the people who get to be involved in these selection processes, right? So the idea of eminent persons, including people who come from diverse backgrounds, built into the commission, diverse social locations built into the commission, was something that was very interesting. Of course, the way it was designed about who would select these eminent persons, and the role of the judges versus the executive, those were all incredibly problematic. But just to say that the idea of a commission per se is not something that I find
If you were to
problematic.
benchmark
But
a commission with other countries, what's a good model for you guys?
I mean, again, I don't want to speak for, this is not something that we've done in the book, so I don't want
Right.
to speak for others.
Fair enough.
But South Africa is a good example, and I wanted to say something about South Africa,
Right.
even outside of the context, because one thing that South Africa does is, apart from it's otherwise its processes, there is transparency in what happens inside the in during the selection process. In fact, there was a case that went up to the highest courts there about there should be lesser transparency because people wouldn't be as candid, and the court said, no, you have a duty of candor, right? You have a duty to ensure that you speak candidly, and these are people who are applying to the highest courts in the country. They can bear this kind of public scrutiny. In fact, one of the reasons given very often for why the Collegium should operate in secrecy is to say that it would be insulting to potential candidates for us to put our discussions out in the public. In fact, even in cases that have gone up before the Supreme Court on seeking under the RTI Act, seeking information, the court has said, yes, candor and all is very well and good,
Hmm.
but we have to see that there are other sort of sensitivities involved and personal information involved. Unfortunately, if you're standing for if you're trying to occupy a very important public office, then that's the minimum expectation that you have, that you are putting yourself out there in the public domain, and you're like your judicial philosophy, your other attributes of you that impact your functioning as a judge should be up for discussion. And that's precisely what accountability looks like. So therefore, to say that we are not like that, and our judges, we will not get good applications, etc., is incredibly problematic when the judges themselves put the similar, kind of requirements of candor, of transparency on politicians for when they are filing their nominations. You would expect that at the very least, it doesn't have to be as extensive as you have for a politician, but the expectancy that when judges are deliberating, the deliberations that they have, and the material on the basis of which they're deliberating is out there in the public. That might not even require a full-fledged commission. That could still even just be the Collegium, which is more open and transparent, but also supported by a secretariat. And I know there have been some efforts towards that end recently. But one of the things that the NJC judgment said, that is that the Collegium is incredibly problematic in how it operates, because it operates not just behind a veil of secrecy, but there's also secrecy. I mean, the judges themselves don't know much. I mean, we've seen in this very year, there have been appointments where after the appointment, there's been information coming out about a judge, about her, alleged, not alleged, her hate speeches that she'd made, and the Chief Justice of India saying, on in open court, that, oh, we were not aware of this. And you would think that they'd have a better screening process, even when it comes to appointments.
I think just to add to your point about how important candor is, and you really can't sort of get away from it. Recently, since the Collegium is going through its own growing pains, of late, actually the Collegium has taken to publishing public rejoinders whenever the executive stops an appointment, and the executive is actually quite mum and sphinx-like about it, except it's the court that thinks that it needs public opinion on its side. And I think that was a smart thing to do, looking at it from my POV. it didn't go anywhere, but at least silence at that time would have even made it worse. At least it's out there that the IB is playing this sort of blocking role in the Collegium appointment system, which it was never supposed to, at this level at least. Cool.
And for these
Will
reasons, and
and
for
for
these
these reasons.
reasons.
Exactly. So I think, so I mean, you can't, I think in a public thing to get away from, I think public scrutiny is just it's not possible. In fact, that for me is one of the, I mean, obviously, like you're right, there are many problematic things about the NJAC, but at least it might have been public. With that, I'm going to go on to the next question. One of, which since you mentioned Ranjan Gogoi, one of, and this is really again one of the things that really come into the limelight is the idea of the fact that judges have a post-retirement life, which is often quite vibrant in India, and this leads to again, as you show in your book and as previous studies have shown, that data has shown that this leads to a tilting of the needle when it comes to cases being decided by these judges, especially at the end of the tenure. So, walk us through that. What do you think your policy prescriptions are to prevent this? What do other countries do?
Well, I think that there are a couple of observations worth making when one looks at other countries. The first is that the mandatory retirement age in India is below the norm internationally across countries that have mandatory retirement ages. And of course, there are some countries like the United States where for the judges in the United States court system, there is no mandatory retirement age at all. Now, that may come with its own set of concerns. If
Right.
there's currently a very serious dispute ongoing in one of the uh, appellate courts, one of the intermediate appellate courts in the United States, involving claims that a judge is too old to perform their role, and that judge insists otherwise. But uh, but the key observation here is that the mandatory retirement age in India for the Supreme Court is well below the international norm in a day and age where, as you point out, individuals who are retiring from the court at age 65 are often able to have a very vibrant career for years to come after that. And that does call into question whether a retirement age that youthful, if you will, is appropriate in the current times. Having a longer tenure for Supreme Court judges does have some benefits in our view. A longer time on the court would allow a greater sense of continuity from case to case and from panel to panel, and I think that fits that dovetails very closely with our recommendations with regard to shifting the court's role towards a constitutional court where it's focused on precedent and setting norms. If judges have a longer time period on the court, a longer tenure on the court, they can work towards establishing that sense of norms, that sense of continuity, rather than revisiting the same questions over and over year after year, reinventing the wheel, so to speak, as each new cohort of judges arrives. So one benefit that to the concern about the influence of post-retirement jobs on the Supreme Court judges' activities actually spills over to another aspect of the book that we talked about, which is the concern about creating norms and acting as a constitutional court. Simply by extending the tenure of judges, it limits the significance of the post-retirement period while giving them a greater opportunity to fulfill their roles as judges while on the Supreme Court.
Two other sort of things to think about here. One is, and this is very often advocated, a cooling off period before one can, take on any other job. That would require, to my mind, if one is to have a cooling off period post retirement, then at least ensuring that the benefits and salary and benefits that a that a Supreme Court judge
Mhm.
receives during the cooling off period is at least commensurate to what they received while they were in office, so that they're not put to a disadvantage because of a mandatory cooling off. Um, the other solution that is advocated generally might not be palatable or suitable in a country, in an impoverished country like India, is to ensure that post retirement also judges retain all the benefits and salaries that they did while they were on the bench. But this is something that courts around the world do to secure, precisely for these reasons, to
Right.
secure judicial independence. The final point that I will make, though, which is a problem system wide, is that we've now created, parallelly to the Supreme Court, this set of tribunals which are supposed to be staffed at the highest levels by a retired judge of the Supreme Court, or someone who's been a judge of the Supreme Court,
Right.
or even a judge of the High Court. And what is happening, and these are obviously, the executive has a lot of role to play in appointments to these positions. So one, of course, the as the court knows very well and has been fighting for the longest time with the executive, these tribunals themselves have, challenges around independence of those tribunals because of executive involvement in their appointment. But the spillover effect is that there is this sort of pandering effect that studies have found, where judges, because they want to be on these tribunals, particularly they often want to be in a place like Delhi, where the principal bench is located, and where they've moved while they were on the Supreme Court. Uh, there is, there is all this incentive to pander to the executive, and so you're anyway facing an independence problem in the tribunals. But because these are supposed to be staffed by Supreme Court judges or retired Supreme Court judges, or retired High Court judges for that matter, there is a spill-on effect on the independence of these entities as well. And so, therefore, in thinking about the validity of these tribunals, and these tribunals that are sought to be tribunals at a level where they can replace the High Court, etc., I think this is an element that doesn't get captured at all. That you're impacting not just the independence of those tribunals, but also the independence of the courts.
Yeah, I mean, it's kind of ironic that the idea of an office of profit constantly makes news, where you're giving positions to people in the legislature, but I guess this might be an even more complex problem to solve. I'm going to end this fascinating discussion by trying just broadening out from your book. So you've given a lot of policy prescriptions, and I want uh, to marry it to right now what is making news, the news cycle right now. And the news cycle for the last almost a decade has been this idea that the judiciary is not placing enough checks on the executive, especially the union executive. And of course, like I said, this is not part of your book, so I would like you to answer it at a personal level, if possible. Do you think that the policy prescriptions that you're putting forward would have solved for this issue? It's a big question. So,
I'm happy to go first on that. Uh, I think our policy prescriptions would not allow the Supreme Court to evade its responsibility. One of the elements of this heavily backlogged court is that it has a ready-made excuse for not deciding cases, for saying that, we are going to take some time to set up a constitution bench, and by then the matter becomes infructuous, only because, deciding by not deciding, because delay is a convenient shield. We have so much work that we are doing that we just haven't gotten around to it. It's not that it's not important, but we haven't gotten around to it. And we discuss in great detail the electoral bonds matter. I mean, if there is anything more important to the Indian democracy, I don't know what that is. What case is pending before the courts that might be more central to the Indian democracy, and the courts just hasn't gotten around to dealing with that case. So it would limit the ability of the court to evade its responsibility, of the core responsibility of holding the state to account for violations of the Constitution, and perhaps give it more time to make more considered decisions when it does get around to deciding these questions. Beyond that, our book is a book on data and numbers and what the data and numbers show about the court. What we haven't done is look at a range of other crises that the court might be facing, such as in qualitatively how it is performing its function, which is a more qualitative assessment of the working of the court, perhaps even more important at this current moment that we are witnessing. But that's not something that is reducible to data. And so in this project, beyond looking at the capacity of the court
Hmm.
to deliver to do its job, we haven't gone into those questions. I have lots of opinions on it, but it's not in this book.
I'll just I'll add one
Sure.
element, I guess, to what Aparna said, which is when one considers the role of the judiciary and its need for independence and providing checks and balances with respect to the executive and the legislature, there's at least two main pieces to making that work. One is that the judiciary has the capacity and the structure of their work is such that they are pushed to exercise that role of checking the other branches of government, and that's what Aparna was emphasizing, was that does the court have the capacity to act, but also is the court lacking the capacity to avoid acting, right? And that's such a big part of the delay and the deciding not to decide. The other piece of it is, what are the incentives? What are the incentives that the judges face? Is there a sense in which judges are beholden to interests that they should be independent from? And I think one of the great strengths of the Collegium system, and the reason why we don't jump to criticize it or say it should be abandoned entirely, is it does make the judges very independent from the political parts of government in their selection. But there's another side of it, which is the retirement side. And as we were just talking about,
Mm.
the way that the mandatory retirement system works is because the tenure on the Supreme Court is brief, because the best jobs afterwards are often government jobs, because there isn't the economic security available for judges after they retire, unlike, as Aparna pointed out, in so many other countries. All of that creates incentives for judges not to push back against the elected branches of government, against the executive, against the legislature. And so, in that respect, some of the proposals in our book would, I think, help not just with pushing the court to do the right thing when it is time to do the right thing, but also to remove some of the pressure on the judges to maybe pull their punches when they should be swinging at the actions that the government might be taking.
And resulted in a truly more powerful court in that sense. Like they would have more freedom and to act when they wanted to,
Mhm.
and so on. With that, I'm going to end the discussion. This was a fantastic. We've crossed an hour, which is always a problem with my producer. This is a fantastic, erudite, and very meaty discussion. Thank you to the two of us. Unfortunately, Seetal couldn't join. Please say hi to her for me. The book is Court on Trial. Here it is. Please give it a read. In case you like what you heard, again, scroll.in/contribute. Please become a member. Try and support our work. Try and support independent journalism in India. Thank you so much, Aparna and William, for your time. Appreciate it. Bye
Thank you
bye.
so
Thanks,
much.
Shoaib. Thanks for having us.